If you're a professional in Toronto facing a fraud over $5,000 charge, I know your world has probably just been turned completely upside down. So this is designed to be your guide, a clear path forward when you're in the middle of a serious crisis.
This really just hits the nail on the head, doesn't it? It's that whiplash, that feeling of shock and, frankly, terror. One minute, you're building your career, and the very next, everything, your reputation, your freedom, your entire future is hanging by a thread. It's a truly devastating place to be.
Okay, so let's dive right in. Before you can even think about fighting this, you have to understand exactly what this charge means in the eyes of the law. This is ground zero.
Right, the key phrase here is indictable offense. That's not just legal jargon. It puts this charge in the most serious category of criminal offenses in Canada, on par with major violent crimes. So don't let the term white-collar crime fool you into thinking this is somehow less severe. The consequences are absolutely life-altering.
And speaking of consequences, let's talk about the stakes, because they are incredibly high, not just for your future, but starting right now. This is not a problem that you can just wish away.
This slide really lays out the two-front war you're suddenly fighting. In the short term, you're dealing with bail hearings, you might have to surrender your passport, and your job could be in immediate jeopardy. But the long-term stakes, that's the stuff of nightmares. A permanent criminal record, getting banned from travel, especially to the United States, and a restitution order to pay back every cent. It's a total disruption of your life as you know it.
So let's throw some hard numbers out here to really put this in perspective. It all starts with this number, $5,000. That's the magic number that pushes this into the major leagues of criminal charges.
And once you cross that line, the potential penalty just skyrockets. The maximum sentence? 14 years. Just let that sink in for a second. 14 years in prison.
And it gets even more serious. If the amount is over $1 million, the law steps in and ties the judge's hands. There's a mandatory minimum sentence of 2 years in a federal penitentiary. That's not a possibility, it's a certainty without an incredibly strong defense.
Okay, I know that was all pretty heavy, but this is the single most important thing I want you to hear right now. Getting arrested is just the beginning of the legal fight. It is not the end. So let's shift gears and talk about the solution. There is a blueprint, a path forward.
A really powerful defense strategy is almost always built on these 3 pillars. It's not about finding one magic bullet. It's a coordinated attack on the prosecution's case from every angle. First, you look at how the police ran the investigation. Second, you go after the evidence they claim to have. And third, and this is often the game changer, you challenge the very idea that you ever intended to do anything wrong. Let's break those down.
You know, what's so interesting here is that police mistakes can actually become your biggest advantage. The Charter of Rights and Freedoms isn't just some dusty document. If the police searched your office or your computer without the proper warrant, that's a huge violation. If the case takes way too long to get to trial, that's another violation. A successful charter challenge can get key evidence thrown right out of court, sometimes collapsing the entire case.
Look, fraud cases are built on mountains of documents, what we call the paper trail. But here's a little secret. Just because the police have a document doesn't mean they can use it in court. The Canada Evidence Act has super strict technical rules for how things like bank statements and business records can be admitted as evidence. A top-tier legal team will pore over every single page, and if the Crown missed even one tiny step, that evidence can be deemed inadmissible. And when that happens, their case can crumble.
Now, this might just be the most powerful defense in the entire playbook, going after the mens rea, the guilty mind. See, the Crown doesn't just have to prove that something bad happened. They have to prove beyond a reasonable doubt that you knew what you were doing was dishonest and that you intended to cause a loss. There is a massive legal canyon between criminal fraud and, say, a business deal that went south or even just sloppy accounting. Proving you never had that criminal intent is absolutely crucial.
So, we've laid out the blueprint for a defense. The big question is, who can actually pull it off? This is where having a specialist is not a luxury, it's a necessity. And it's exactly why a firm like Daniel Brown Law is the go-to for these kinds of high-stakes, complex cases.
Just look at this. This is what you should be looking for. It's not just about hiring any lawyer. It's about getting a team with a specific, proven track record in winning complex fraud cases. When a firm is consistently recognized by things like best lawyers in Canada, that's a signal that they have the respect of the entire legal community. They know how to handle cases that are buried in paperwork, and just as important, they get what's at stake for a professional like you. They understand this is career-ending stuff.
And this right here is so important.
A fraud charge isn't just fought in the courtroom. It's a full-blown PR crisis. Your reputation is being attacked in public. A truly expert firm doesn't just handle the legal side, they help you manage the crisis. They give you advice on how to handle the media, what to say, what not to say. They're not just your lawyer, they're your crisis manager.
All right, I'm sure you have a million questions racing through your mind right now, so let's just tackle two of the most urgent and common ones head-on. This is the big one, isn't it? Is there any way to make this all go away without having to go through a long, public, and incredibly stressful trial?
And the answer is a clear and resounding yes. It is absolutely possible. Using all those strategies we just talked about, poking holes in the evidence, finding those charter violations, giving the Crown a plausible, non-criminal explanation, a skilled lawyer can often convince the prosecution that their case just isn't strong enough to win, and that can lead to charges being withdrawn entirely. This is why you need an expert on your side from day one.
And the next question, the one that keeps people up at night, can I avoid going to jail?
And again, the answer is yes, you can. With the right legal team fighting for you, prison time is not a foregone conclusion. Depending on the details of your situation, an experienced firm can negotiate for all sorts of alternatives, from getting the charges dropped to arguing for a sentence that involves no jail time at all. It all comes down to the quality of the defense that's put forward for you. So, what's your next step? This part is absolutely critical. From this moment forward, every single hour matters. And if you take nothing else away from this, please take this. Do not, under any circumstances, speak to the police or investigators without your lawyer. Your right to remain silent is your shield. Use it. At the end of the day, it all boils down to this one thing. When you're facing a charge this serious, the single most important decision you will ever make is who you choose to have in your corner. Your career, your reputation, your freedom. It's all on the line. So the only question left to ask is, are you ready to do what it takes to protect your future? If your answer is yes, then the help you need is right here. For a completely confidential consultation to go over the specifics of your case, reach out to the team at Daniel Brown Law. They're ready to start building your defense right now.